Okay, let's get started again. For the second session, we're going to talk about retirement plan developments and updates, new laws, regulations, guidance, and some case law developments. Again, my name is Tim Arends. I'm with the Benefits and Compensation Group here at Dorsey. To my immediate right is Liz Deckman. She's also a partner in our Benefits and Compensation Group in Seattle. You heard her the first session. Next to Liz is Paul Hiring in our risk litigation practice group. And then we have Holly Fissler, who's a lawyer in our Benefits and Compensation Group, and Tim Goodman, who's also a partner in Benefits and Compensation Group. So with that, I think we've got new sign-in sheets. Let me remind you about that to make sure you sign in for this session as well, because they're tracked separately for some reason. Why don't we get going? Here's what we're going to talk about in this session. Kind of a lot of odds and ends, I guess. I'm going to lead off with pending legislation that's out there, known as the Secure Act. The Secure Act, setting every community up for retirement enhancment.
You gotta love those acronyms.
Yeah.
They're fabulous.
Is really kind of a hodgepodge of things that have traditionally bipartisan support. I was on Capitol Hill this summer, and when we were meeting with some of the staffers, apparently this bill has more co-sponsors than almost any other bill in history, which is evidenced by the fact that it passed the House in May, 417-3. Since that time, it's been kind of in limbo. Senator Ted Cruz from Texas has a bee in his bonnet about provision of the act concerning Section 529 education accounts, and through some procedural wrangling has prevented it from going to a vote in the Senate. But it has wide bipartisan support, and a lot of the things in it are miscellaneous items that really aren't that controversial. Okay, so the other thing I guess I'll add is everybody, well, not everybody, but a lot of people thought it would be enacted late this summer. There's still time. It might get slapped on to some must-pass legislation at some point, but I've got a number of effective dates in here. Obviously, the later we get, the more likely those would get pushed off, even if it does get enacted yet this year. Okay, key provisions in the bill. One of them is regarding multiple employer plans. The idea here in the bill is to enhance the ability of employers to participate in multiple employer plans. The Act calls them pooled employer plans, but the theory is that if we can have these multiple employer plans, these multiple employers join together in a plan, we can get more smaller employers in a 401k plan, and thus their employees participating. So what it does is it permits unrelated employers to join together under a single plan, as opposed to things we'll talk about a little later with associations and groups. One of the key elements to this, though, is that it would remove the compliance risk for an employer joining the plan if some other employer in the plan had a compliance issue. It's not going to affect the entire pool. The effective date, as proposed, or at least in the House version, is 12/31/2020 for plans beginning after that date. Next item is auto enrollment. Currently in 401k plans that have auto enrollment, you can have you can auto enroll up to 10%. The Act would increase that to 15%. Safe harbor plans. On the next slide, the Act makes it a little bit easier for employers to adopt safe harbor plans late in the year. You can adopt a safe harbor plan if the Act passes up to 30 days before the end of the plan year. It also eliminates the notice requirement for non-elective safe harbor plans, so plans that provide the non-elective contribution as opposed to relying on a match. And also, even if you get towards really the end of the year, you can adopt a safe harbor plan if you provide a 4% non-elective contribution. You know, again, these are all wait and see, because until the bill passes, we don't have anything yet. Minimum required distributions. The provision in the bill simply raises the required distribution age, minimum required distribution age from 7.5 to age 70. Another thing that's been kicking around for a while is lifetime income out of 401k plans. And what the act is trying to do is encourage plan sponsors to utilize more lifetime income type vehicles, annuities essentially. We've had those obviously in pension plans for a very, very long time, and some 401k plans have them as well. But what the act would require is that an employer annually provide participants with an estimate based on their account balance of what a life annuity would look like if they went with a life annuity under the plan. The other key element from an employer perspective is that it provides fiduciary relief for annuity provider selection. That has been a concern of some employers in terms of offering annuities because they're afraid of maybe some repercussions if the insurer has problems down the road. Another provision in the act, part-time employee participation. Here, plans would be required to include part-time employees who work 500 hours or more in 3 consecutive 12-month periods to be in the plan. Again, the idea is to try to increase plan participation. And in some ways it makes sense because if you've got an employee that's doing 500 hours a year for 3 years in a row, one would think they'd be fairly permanent. So it's trying to address, I think, getting part-time people in, but also a little bit reasonable in that not all part-time people have to be in. Some odds and ends. There's a provision regarding consolidated Form 5500 filings for control groups to make it a little easier for those types of employers to comply with the 5500 filing requirements. Penalty-free withdrawals for up to $5,000 for childbirth and adoption expenses. There's a provision regarding post-death IRA distributions where currently if you inherit an IRA and you're a particular beneficiary, you can extend the distribution of that IRA over your life expectancy. This would squeeze that down to 10 years. Then finally, removal of age 7.5 limitation on IRA contributions. Currently, if you're over age 7.5, even if you have earned income, you cannot make an IRA contribution because of the age limitation. This would eliminate the age limitation where more people are working over past age 70. They'd still be able to make an IRA contribution. There's a couple of other kind of real odds and ends in the act. There's, like I said before, a 529 provision that nibbles around the edges of that, but these are the primary provisions affecting retirement plans. And we'll stay tuned and see what happens. Liz?
Okay.
I have a question.
Yeah.
So if they don't pass it this year, since it passed the House, and they really just want to repass it and send it as is, they have to go back and redo it if they want to change the effective dates?
I would think that they would. Tim, I don't know, you're kind of a legislative guy here, Ed.
Yeah, I think that's absolutely the case. It should be.
Let's repeat the question, though.
Oh, I'm so sorry. So if the Senate fails to pass the Secure Act this year, and let's say the Senate passes it next year, we would then have to go back to the House for another vote. And I think the answer would be yes, to make sure, because the Senate would have, at that point, revised the effective dates in the language. Unless the Senate doesn't change the effective dates. I mean, obviously, some people wouldn't have. Maybe there would be some people trying to take advantage in advance thinking it would pass or something. Maybe the Senate doesn't change the effective dates, but if they change the effective dates, it would have to go back to the House. It would seem like it'd be a pretty sure thing to pass if the only thing they're changing is the effective dates. So that should be hopefully not too much of an issue. Thank you. And I should say, and as you know from the first presentation, we welcome questions. So thank you for your question. Any questions you have as we go through, this is great. Liz?
Sure. So I am going to talk about some very anticipated regulations that we finally got from the Department of Labor. I will tell you that it sounds fabulous to have new electronic disclosure regulations from them, but I don't, and they're a step up, but I don't think that they are a complete panacea of our electronic distribution woes. And we'll get into that a little bit later. Excuse me. So last month, we have these new regulations. The concepts that you have to think about are covered documents and covered individuals. These proposed regs sort of follow an administrative order by an executive order by the Secretary, actually by Trump, I think it was, who was told Secretary of Labor and Treasury to work together to try to get some more easier electronic disclosure rules for participants and ERISA plans. And this is what they came up with. So the covered documents, these are the documents that you can actually send pursuant to this new sort of safe harbor that the Department of Labor has proposed. Unfortunately, at this point in time, it's only for retirement plan notices that are subject to Title I of ERISA, sort of SPDs, summary plan descriptions, SARs, those kinds of documents. You will note that auto enrollment notices are not on this list, which is kind of a sad thing because oftentimes you do a QDIA notice and an automatic enrollment notice together. And those kinds of notices that aren't subject to ERISA Title I are not available for this particular electronic disclosure rule. If an individual actually requests a document, even if it is subject to this rule, you have to give it to him or her or them in hard copy, even if it's available electronically. So again, you're going to have to keep track of who is out there and what kinds of notices you're giving and if they want to have it in hard copy. The covered individuals are persons who provide an electronic address, like an email address or a smartphone number. What I would suggest doing is immediately, if you're not already doing this, getting people's personal email addresses. My guess is that this kind of rule is going to be implemented, and so it will be good to have a head start on having people's private email addresses. Also, for your employee population, if you've assigned that person an email address, you can use that email address, especially if you have a data plan associated with that email address. Most of us, I think, probably do. So those email addresses work as long as they're still functioning email addresses once they leave your company. Obviously, that doesn't work. As I said before, people can ask for documents via hard copy, and they can actually opt out of the electronic distribution safe harbor. That creates sort of an administrative issue for you all because now you have to keep track of who can get, who has emails that you can use and who will not be getting emails. Again, I guess we sort of have that rule right now, knowing who has, for example, access to a computer for work issues, but this is a completely different sort of methodology that you'll have to be thinking about. What's nice is that for terminated employees, you can use private email addresses as long as they continue to work. If they don't continue to work, they change providers, they stop an email address, then you're going to have to try to fix that. And you fix it by sending it to another email address that you have on file for them. You have to sort of treat them, if you can't find a new email address for them, you have to treat them as a person who has opted out of the electronic disclosure rules. And before you post any disclosures, you have to give each of them an initial paper notice saying that these documents are going to be furnished electronically, they have a right to receive and obtain paper versions free without charge, and that they have a right to opt out. So a new notice, paper notice that has to go out to people. Once you've given that paper notice, though, there's a notice of internet availability that you can use. You give via email this notice of internet availability to each covered individual for each covered document. You have to provide that notice by the time that the notice is supposed to be posted under ERISA. I find this interesting. You can contain only the information that the DOL says. We think we might be getting a sort of a model notice, except you can have pictures, logos, and design elements that aren't misleading, and they have to be written in a manner calculated to be understood by an average plan participant. And the DOL has now given us a test for knowing whether or not these notices are understandable. And it's a FLESH score. It has to be above 60. Has anybody used FLESH here? No. Okay, well, the scuttlebutt is that if you put the regulations into FLESH, which is some product, I don't even know what it is, that the regulations fail this rule. So the regulations are not calculated to be understood by average plan participants. You can have combined notices that cover sort of the annual notices that you give out. You give that once each year, but then you have to do it again within 14 months. So you can't wait for longer than 14 months before reposting.
There's a question.
Oh, sorry.
Is the right saying that the notice has to be understood by the flush score, or the SPD has to?
Yeah, good question, right?
Repeat it.
Yes, so the question is whether or not the notice only has to be understood by plan participants, or whether or not the actual document that you're telling people is being posted is understood by plan documents. These regulations only talk about the notice, but I think that the general rule is that your SPDs are supposed to be understood by plan participants. So far, I mean, this is only for these regulations. There's nothing that says that the flush score has to also apply to the SPD. Although, you know, if you have, it's going to be hard, I think, to make an SPD satisfy a flush score of 60. I haven't tried to do it yet. So, but it might end up being sort of a default. Your internet has to make sure that, you know, it actually works. And if the internet fails at some point and there is a temporary unavailability of documents, you have to fix that as soon as you possibly can. You have to, as it says, take prompt action to cure problems. So again, you're going to be working a lot with your IT folks, not that you're not already, but this is just another level of interaction with them. Your system for delivering notices of this internet availability has to alert you of invalid electronic addresses. And again, I said if it doesn't work, then you need to cure that. And if you can't cure it by finding a new electronic address, then you need to send it to them hard copy. Presumably, we think that the regulations will be effective 1/1/21. The DOL has asked for a really fast turnaround on comments for the proposed rule, and that's by November 22nd, which is a very short period of time. It tells me that they're very interested in having these rules become finalized as soon as possible, and they're supposed to be applicable for the first calendar year following publication of the final rule. It may be that they say, okay, you can rely on these regs as of whatever date is given when they're published, even though the technical formal date will be 1/1/21, but I guess we'll see. On to hardship distributions. I think this is Holly.
Yes, this is.
Excuse me, I'm going to reach across you.
Thank you. Well, another one of the developments that we have in the retirement plan field this fall were the final regulations that were published for hardship distributions. These final regulations, in addition to the proposed regulations that were issued, were designed to provide guidance for two main pieces of legislation over the last couple years. The first one being the Tax Cuts and Jobs Act of 2017. Notably, that law limited casualty deductions under Code Section 105 to only presidentially declared disasters. What this ended up doing is it ended up limiting the casualty losses that would qualify as a safe harbor distribution event, because the safe harbor distribution regulations refer and cross-reference to Code Section 165 for the casualty deductions. So following the Tax Cuts and Jobs Act, plan sponsors were looking for guidance as to whether or not this was going to apply to that specific safe harbor event, because basically it would have severely limited the availability of hardship distribution. The second piece of important legislation became the Bipartisan Budget Act of 2018, which made very specific changes with respect to hardship distributions. Most notably, the removal of the requirement to suspend elective distributions for 6 months following a hardship distribution, removing the requirement to take loans, all available loans, prior to an individual being able to take a distribution, And then also finally, being able to expand money sources, which would allow individuals to also access qualified non-elective contributions, qualified matching contributions, earnings on those amounts, but also earnings on the elective deferrals. The reasoning behind this being that all of these money sources have very similar characteristics and are usually accounted for in very similar ways. As part of the guidance that we've received, there are certain types of administrative practices that employers are taking a look at now that we have guidance on what is required and when. First of all, the requirement to eliminate the 6-month suspension of elective deferrals is optional for 2019, required starting January 1st of 2020. There are also changes that can be made to safe harbor requirements. Looking back at the confusion that was remedied by the final regulations, plan sponsors need to be able to kind of restore the safe harbor expense for casualty losses that was kind of tweaked by the Tax Cuts and Jobs Act. So optional in 2018 and 19, but required starting January 1st of 2020. Plan sponsors are going to be able to put back into place that hardship distribution event in the event of any kind of casualty loss, without regard to any of the changes that suspended the casualty losses under 165. Additionally, employers have the option of putting in place another safe harbor distribution event. Now, this being that in the event an employee resides in their principal place of residence or their principal place of employment is in a location that is a FEMA designated area following a federally declared disaster, employees can take a hardship distribution not only for losses, but also income losses as well. The benefit of this additional distribution event is that it allows plan sponsors and participants to take distributions when they need it and not have to wait for the periodic relief notices that come out from the IRS, usually sometimes within weeks and oftentimes within months following. So this allows plan sponsors and participants a bit more flexibility and reactivity in those situations. These are optional starting in 2019. Also, expanded sources are optional in 2019. Also, starting in 2019, employers, plan sponsors are able to decide whether or not they would like to allow participants to take hardship distributions before or after they've taken all available loans. It provides employers flexibility to determine exactly how available the hardship distributions need to be, depending on their plan's needs. The pesky facts and circumstances test was eliminated in the final regulations. This was the test that employers, plan sponsors needed to apply when taking a look at whether or not there was actually an event for hardship distribution. So instead of looking at the totality, we have very specific objective standards. So looking at the need, the amount, whether the employee has obtained all available distributions, and then the plan sponsor can reasonably rely on the employee's statement that they have done all of these required steps. Optional this year, required starting January 1 of 2020. Amendments, there are different time periods for the different types of plans. For individually designed plans, it's going to be the second calendar year beginning after the issuance of the required amendments list. So assuming that this would appear in the 2019 RAL, the deadline for the required provisions would be in by December 31st of 2021. And obviously, optional amendments would have to be by the end of the year in which the optional amendment change took place. Pre-approved plans and 403B plans have their own timing rules as well.
Great, why don't you hand that down to Mr. Arends? So on to another topic, and this is the definition of a fiduciary. And being the somewhat middle of the presentation, I decided I needed to tell a little bit of humor here. You could view what I'm going to talk about as either, since we're just past Halloween, the next installment in your favorite zombie movie, or perhaps just that creeping Charlie you know will be there coming spring and you can't get rid of it out of your yard. Whichever analogy you care for, the definition of fiduciary regulations about that aren't going away, but people, apparently the regulators just can't take a hint that maybe these are very complicated topics. I'm not going to read through the slide here. We're on slide number 17. But basically, this just gives you a very abbreviated version of the history of the fiduciary regulations at the DOL. And the most important point is the DOL plans to issue yet again proposed regulations at some point. It's on their work plan yet again. Like I say, pretty much like your Creeping Charlie or zombie movie. The SEC, of course, has also issued regulations, and they are not very much better. As our next slide will tell you, of course, the demise of the DOL fiduciary rule came in the courts after the Fifth Circuit had vacated that. The DOL withdrew that regulation, and the Trump administration didn't try to seek further review of it. And now the SEC fiduciary rule is also being challenged. I guess just a small observation here. I mean, I think for plan sponsors, what these fiduciary rules have really done, hopefully, is help raise awareness of when individuals might be fiduciaries. And I think it probably has raised participant awareness, too, of different fiduciary concerns of who's doing what and what is being monitored. And so that's maybe the most helpful thing that these lengthy, drawn-out regulations and litigation involving these regulations have done so far. But as you can see, both from the court challenges with respect to the SEC rule and the fact that the DOL is planning to go at it again, they think there must still be some merit in trying to provide some more guidance, and maybe there is, but obviously this has just been a very contentious area. So just for everyone, I've been trying to think about this and thinking to myself, how could these agencies do this better? And I think that what they need are some better spokespeople. I have to say this, no offense to the current Secretary of Labor or Secretary of Treasury, Secretary or SEC people, but I think they should consider Jackie Chan and Chris Rock. They did great together through 3 rush hours. You'd have one guy who'd be a fast talker and could help maybe pull some things over, another guy who's sort of swift with his hands. I just think that maybe they should consider that action duo as the spokesperson for the next go-around on the DOL regulations. If that happens, I will apologize to everybody, but at least we'll have a lot more fun with the next go-around on the fiduciary rules. With that in mind, I am going to turn it back to Mr. Arends to talk about multiple employer plans for just a moment here.
Okay, so we touched on these in the Secure Act, which is designed to open them up to have all kinds of employers join together and create a multiple employer plan. We don't have the Secure Act yet, so the DOL is still active in this area on its own. And we had regulations this summer that provided clarity from the DOL perspective on what a bona fide group or association is. Generally speaking, the requirements are you have to have a formal organizational structure. It has to be controlled by the employers, and the employers of the organization also have to control the multiple employer plan. There needs to be a substantial business purpose around what the organization is or does. The plan has to be limited to employees of the employers of the organizations or former employees and beneficiaries. There needs to be a commonality of interest with respect to the group, which would be like an industry group or professional association, or some geography commonality, like in the same state or in the same metropolitan area. And then lastly, each employer member must have at least, that's a member of the MEP, must have at least one employee that's participating in the plan. PEOs have similar requirements, a little bit different, but for the most part line up with the requirements for just the regular multiple employer plan. A couple of things to note about this. The regulations apply only to 401k and 403b defined contribution plans, and financial institutions are precluded from grading these animals. The other thing that's going on is there was a little bit of administrative relief. There's an executive order followed up by a field assistance bulletin dealing with reporting on Form 5500s, where apparently it's been a problem for some employers to correctly report whether they're a multiple employer plan or not. And this field assistance bulletin gives some relief to that.
Great. Thank you, Tim. Now it's back to me for a couple of very quick updates on some regulations that are out there or guidance. One bit of guidance we've received regarding DB plans and lump sum windows. So as you all may recall, previously, a number of entities had gone into the Treasury and IRS and had gotten private letter rulings saying they could commit to doing lump sum windows, including offering lump sums to people in pay status. Then the Treasury rethought that, thought maybe that's not the best of ideas for those folks who are in pay status, that it'd be better and more secure for the retirement. And so they restricted the ability when you're doing these windows to offer these lump sums to in pay status retirees. Earlier this year, they came back and said, well, we've rethought that position, and now again, you can offer lump sums to people who are in pay status. I know not many people these days have DB plans. Those that do have them, though, are looking actively at how they can reduce their risk under those plans, and so I think this may be of interest to employers in terms of, at some point in the near future, doing maybe another lump sum window, trying to look at, can we maybe, again, lessen some of our exposure and risk in terms of volatility under the plans. So that's one bit of DB development. There's another DB development as well. That has to do with the hybrid determination letter submission. So basically, the IRS had indicated that a few years back that it was changing how it did determination letters for individually designed plans. As people may be familiar with, basically individually designed plans were on a 5-year cycle. Different EINs were submitted one year, then another 2 EINs the next year, then another 2 the next year. It was meant to try and level out the IRS workload somewhat. Due to staff and other issues, the IRS decided to cease doing submissions like that and only to take requests for determination letters on individually designed plans under limited circumstances, such as you've set up a new individually designed plan. This year, they announced a couple of exceptions. One was in the context of a merger or acquisition. They have a very limited window for that. A bigger one, though, that I think people are interested in is they also opened up submissions with respect to hybrid plans. And so I think that plan sponsors that have individually designed DB plans that are hybrid plans would probably want to take advantage of this. In general, the thing I would say is, we still don't fully know what's going to happen in the long run. Auditors have always asked when they audit plans, can you show us your most recent favorable determination letter? I think if you sponsor a hybrid plan and you don't submit during this window, the auditors will probably ask you, why did you not submit your hybrid plan during the window when you had a chance? And plus, this is a way that you can then double check that the IRS does indeed look at your language and think that the language is accurate and reflects the code. So I would suspect that any employer that sponsors a DB plan that's a hybrid plan during this window is likely going to want to submit that plan. They'll have to restate it and then submit it during the time period and then seek that new favorable determination letter. And now a bonus, one other thing we had received not too long ago is actually some new regulations regarding Section 401A9. And just so I'm very distinct here, we're not talking 409 Cap A, but 401A9, minimum required distributions. Actually, Treasury and IRS have released proposed regulations to revise the tables under 401A9 as well. These are not effective yet, but basically they would go ahead and extend the period of time over which distributions would occur. I forget when they were last updated. I believe it was in the early 2000s was the last time these regulations came out, so it seems like a very appropriate thing for them to update at this time. But especially if the Secure Act is passed, you might actually see even further changes depending on things like that. But at least there's these proposed regulations that are out there, and I'm guessing that those will be finalized next year. I don't know that there'll be probably too much commentary on those regulations. So there are, even though there's a lot of gridlock in Congress, there has been, I'd say, a lot of movement in terms of developments and guidance. And I'm going to hand it back to Holly here, I think, to talk about one other development, which is welcomed by folks, relief from the IRS and Treasury when there's mistakes.
Yes, practitioners, Tim, have been extraordinarily excited about the updates to the Employee Plans Compliance Resolution System. Everybody has different ways of pronouncing this acronym. I'm going with the shorter version, EPCRS. Just as a go forward here. Now, this updates the prior version of the Revenue Procedure 2018-52, and the most significant changes that we're going to look at today are the expansion of some self-correction opportunities that just haven't been available in the past. These are also quite common correction opportunities, so it feels like this is something that the IRS would like to have in place to be able to resolve those issues that they just might not always have to scrutinize as much just because it's very routine. The first one that we're going to take a look at is the plan document failures. It is a common, it's not an uncommon occurrence that a plan sponsor can miss a required amendment. The new opportunities under EPGRS 2019-19 is that a plan sponsor can fix a late amendment to the retirement plan, provided that the correction's been done within 2 years of basically within 2 years of the end of the year that the plan amendment was supposed to take place. So it's treated as a significant operational failure, so you have that shorter time period to correct, but it allows employers to fix required amendments and interim amendments that just got missed. It is important to note, however, that this relief does not apply to discretionary amendments, just for those required and interim amendments. Also, it's important to note that this is not available to correct the failure to timely adopt a plan document, and all of the corrections do require that the plan sponsor have a favorable determination letter, advisory letter, opinion letter in order to be able to take advantage of this relief. But this is quite welcome relief for plan sponsors. The second area of additional self-correction opportunities has to do with plan loan failures. In the past, the only vehicle available to plan sponsors to be able to correct plan loan failures, especially with respect to the repayment of loans in accordance with the terms of the plan, or plan loan defaults, was to have a taxable distribution to the employee with a 1099-R reporting of that taxable distribution. Now, with the updates to EPGRS, in the event that you have a participant who was unable to repay plan loans in accordance with the terms, there were missed payments, late payments, wrong amounts, this may be corrected, self-corrected by the plan sponsor by taking one of several routes. One, the participant could make a lump sum repayment with interest in order to catch up and to be back where they need to be. The second, re-amortization, including that interest, or three, a mixture of both of those types of methods. The whole goal is to get the participant back on track. However, if it's just not possible to correct the defaulted loan, say for example, we're outside of that period of time for the loan, it may still be treated as a deemed distribution in the year of correction instead of the year of failure. It is important to note, however, that the Department of Labor still requires the Voluntary Correction Program, so the VCP, to qualify for relief under the DOL's Voluntary Fiduciary Correction Program. And it's notable because in order to receive that no action letter, basically saying that there's no fiduciary breach, the DOL is still going to look for that IRS stamp of approval from a VCP. Other type of plan loan failure corrections are also available, such as the failure to obtain a spousal consent. The IRS says, all right, not a problem, you can self-correct, just go to the spouse that the participant was married to at the time, even if they're no longer married, and you can obtain that consent. Now, if they don't provide the consent, then you're back into the VCP program. And this is probably going to affect your money purchase plans and defined benefit plans more often, or transferred assets from those, so it's not going to be very regular, but it does exist. Also, the EPGRS allows plan sponsors to correct failure to limit the number of loans. So say, for example, the plan says you can only have one outstanding loan, but it has been allowing two. You're allowed to put in place a plan amendment as long as it satisfies the code requirements for the plan, for plan loan requirements under Code 72, and that the excess loans have been made available on a non-discriminatory basis or only to non-highly compensated. And finally, operational failures, those times when the plan hasn't operated in accordance with the terms. If the plan has been more generous, if the employee has been receiving more than what the plan document has been providing, self-correction is available for the employer to retroactively amend the plan to conform the plan written terms to the actual operation. But again, it needs to satisfy all of those requirements under the EPGRS. It cannot be discriminatory. It must only result in an increase of benefits, and it has to be available to all employees. So.
Perfect. Thank you. Now a topic that probably people are familiar with, but if not, it's worth becoming familiar with, which is basically, state and local governments for a long time have, I think, been involved in health and welfare benefits or paid leave or other things. Here in Minnesota, for example, of course, with Minneapolis and St. Paul mandating certain paid leave requirements, employers look at those things and it's just a jumble. If you're in multiple states, this is some of the most complicated things you deal with. In the last number of years, those states have also become concerned that their citizens may not be prepared for retirement and have been looking for ways to address that. Here is your first quiz of the day. So I'm going to ask which of these states on this slide are out of sync with all the other states. They fall into two groups, basically. Anybody want to make a guess? You could win a valuable prize. No? Illinois. Okay, so you basically, probably not too big a surprise. What states are doing most of these things? They're in the Northeast or along the West Coast. And then we have Illinois, which apparently also wants to be a trendsetter. In terms of who is trying to enact or is vigorously pursuing enacting sort of state-run retirement programs. And it's kind of funny. I don't know the right way to phrase this, but state-run private retirement programs are basically, the idea is that the state says to employers, look, if you don't offer your employees a retirement plan, you then have to go and auto-enroll those people to take X% out of their pay and send it on to the state, and we will set something up for them. Your only role is deducting amounts from their pay. We take care of the rest, but you're going to be required to do that. Okay. And so far, at least, I believe all this legislation is aimed at entities that don't offer any retirement plan, but you can easily think about how quickly this could be. Well, let's say you've got a 1-year waiting period. You then have to offer those people to go into the state plan or start deducting for them or other things like that. And I think this could cause employers to relook at their plans if they do have like that 1-year wait, if nothing else, to allow maybe elective contributions immediately, or depending on where the Secure Act goes and stuff, even if you exclude people who work 1,000 hours, maybe those people get put in just to avoid any sort of burdensome duties that might fall under these state rules as they move forward. So I'm going to give you a little bit of flavor about this here. The background on this is originally the DOL issued some guidance saying, yeah, we don't think that ERISA is a problem with respect to these state-run private retirement programs, because what you're doing is it's as though you had, say, a workers' compensation or some other state-paid system of leave or something. You're just taking money out. We're okay with that. That, however, was a Democratic president, a Democratic Department of Labor, and as soon as the Trump administration got in, Congress did have a big problem with this, and basically in one of the rare uses of the Congressional Repeal Act, they repealed the regulations that had actually been adopted in final form. And so those regulations aren't out there anymore. But a number of states, and hence you can probably guess, led by Democratic governors and Democratic populaces, have pursued this nonetheless and are trying to move forward. I'm going to take Illinois as one example here. So in Illinois, we've got the Illinois Secure Choice Act. Everybody wants to be secure, apparently. That's something everybody must have very high on their list of things. Basically, and I won't go through all the requirements, but basically you don't offer a plan. You're supposed to auto-enroll and people can opt out. If they don't want to do this, they can still opt out. But you have to go to them and spend a little time and say, hey, we're going to start doing this and set up yet another payroll process. The great learning I've had in my entire career is if it's a payroll system issue, it's always an issue. In terms of Illinois, employers with different numbers of employees have been supposed to be registering with the state in order for them to get things up, and I can give some resources there in terms of things. Now, I think probably everybody both on the phone and here, probably all your entities offer retirement plans, and so maybe this isn't a concern immediately and for you, but think about, sometimes entities have different subsidiaries and maybe they have different plans for different subsidiaries or no plans for subsidiaries. Maybe there's something else going on. It's going to be additional work as these plans progress forward. Another state where it has been trying to move this forward is California, and California, not surprisingly, has now drawn a court challenge. This is fairly new in a sense, this court challenge. But one of the interesting things is the Department of Justice has submitted a statement of interest, basically saying, we think this is a really bad idea that these states are being allowed to proceed with this. So we're going to have to see where all this shakes out a little bit in terms of things. I think that it's a trend worth keeping an eye on, and we will keep, as developments occur, we'll try to keep an eye on for you. But especially if you were looking at your plan, I think there's a lot of trends towards asking, if we're keeping people out, is there really a reason not to allow them to at least do elective deferrals and other things like that? Because that really probably addresses some of these concerns raised by these state retirement plan programs here. I'm going to be turning over to Paul Hiring here for a discussion of our case law. And I just will briefly mention before Paul jumps in, you saw Andrew Hawley the first session, you're seeing Paul now, but you don't know that we have another 40 ERISA litigators. Okay, I'm overstating that number slightly, but a lot of other ERISA litigators here who do very fine work, and we're lucky to partner with them in working on benefits. So Paul, I'll let you take it away.
Well, thank you for that plug. Hopefully you won't need us, but if you do, we're here. I'm going to start with the Supreme Court cases because the Supreme Court's obviously the most important court, and they show a surprising interest in ERISA litigation, although they haven't decided any cases for the past couple of years. Any ERISA cases for the past couple of years. They have 3 on the docket this year, so it's going to shape up to be a pretty exciting year in the ERISA litigation world. The first one is this Intel case, and that involves the issue of the statute of limitations that applies to breach of fiduciary duty claims under ERISA. It's kind of a narrow issue, but the 3-year statute of limitations begins to run from the date the participant has actual knowledge of the breach that the participant's suing about. And in this case, Intel sent out information that disclosed the information that was the subject of the litigation. It was covered in some of these ERISA required disclosures that plan sponsors or plan administrators send out all the time. So they said this guy was had actual knowledge of the subject of the breach because we sent him a notice that described what we were doing. And that's what he's suing about. He said, I didn't read it, so thanks anyway, but I did not have actual knowledge of it because I didn't actually read it. I may have had constructive knowledge of it. You may try and deem me to have knowledge of it based on the fact that it showed up in my inbox, but I don't have actual knowledge. And the Ninth Circuit agreed with the participant that actual knowledge means actual knowledge. That's now before the Supreme Court. Interestingly, the DOL has filed a friend of the court brief supporting the plaintiff in this case, saying that actual knowledge means actual knowledge. It's not constructive knowledge. And the DOL points out that it's subject to the same statute of limitations in ERISA. It gets over 800,000 annual reports filed each year. If it's deemed to be on actual knowledge of all the information in those reports, it has to sue within 3 years. And they say they can't do that. They need 6 years. So if the actual knowledge standard doesn't apply, you fall back to the 6-year statute of limitations that's also set out in ERISA that says the statute runs from the date of within 6 years of the last act or omission constituting the breach. So it's a much longer period within which the plaintiffs have to sue. And that's the DOL's position is, hey, we can't live with the 3-year rule. The case is set for oral argument in early December, and I think it will be pretty interesting to see what they do. The next case, this is the IBM Jander case. This involves ESOP or employer stock fund issue under defined contribution plans that offer an employer stock fund as an investment option. It's a follow-on to the Supreme Court's Dudenhofer decision that they decided back in 2014. It's fairly complicated and it only applies to a limited set of plans, but basically I'll skip through all the history here and kind of get to the issue. And the issue is if you have executives of a company who are sitting on a plan committee and who are fiduciaries. Liz and Andy were talking about that earlier today. Those people may get inside information about things related to the company that are going to cause the value of this, when that information gets disclosed, you're going to cause the value of that stock to go down. There's some accounting scandal, some misstatement of earnings, there's some, terrible product problem that is going to come to light. When it hits the market, the value of the stock is going to go down. So the question is, if you're also an ERISA fiduciary, what do you do with that information? Do you have a duty to do something to protect the plan before the information becomes public? And that's kind of what the Supreme Court got into in the Dudenhofer decision. It says the plaintiffs have to identify something legal that the fiduciaries could have done that would not do more harm than good to the plan. The first requirement is interesting, but in these early cases, the plaintiffs always allege, well, you got a duty to immediately sell all the stock held by the plan right now, Get out now when the value's high, before the value declines. That's in the best interest of the participants. So you have a fiduciary to do that. Well, that's insider trading, and there's no fiduciary duty to do insider trading, so that fails the legal requirement. Another claim was, well, if you can't sell the stock yourself, you should at least tell all the participants that this thing's coming down the road and allow them to get out. Well, that's also insider trading, so that doesn't work either. So the plaintiffs' lawyers had to get creative and think of other things you could do that were legal that would protect the plan. But and one of the things they came up with was this idea that you have a duty to disclose to the market as a whole. When you get this information, you should disclose to the market as a whole, and that is going to be better for the plan than not disclosing. Well, obviously, disclosure is going to cause the stock price to go down, so it's hard to see how that's going to not satisfy the more harm than good test. But what they say is, look, in a lot of these cases, disclosure is inevitable. If you've got an accounting scandal or a product problem, eventually you do have to disclose. And that early disclosure is always better than late disclosure in terms of the impact on the stock price. That's the theory of the lawsuit. And they say, so no reasonable fiduciary could ever conclude that it's better to wait. As soon as you get that information, boom, you got to tell the market. Well, that's very concerning to employers that have these kinds of plans, and there's this kind of complicated interplay with the way the securities laws work. But that's the theory in the case, and the Second Circuit said, well, if you have that allegation in your complaint, you get through the Dudenhofer door. You get past a motion to dismiss and get into discovery and eventually a summary judgment or a trial. But just getting over that threshold is hugely concerning to plan sponsors, because you have to do all the stuff that goes along with the lawsuit. Discovery is hugely expensive. There's tons of money involved in these lawsuits. It just creates a lot of angst. They wanted a firmer bar at the courthouse door, and that's what the Dudenhofer decision gave them. If the plaintiff's theory is correct, that all you have to do is put in 2 sentences that say it's always better to disclose early, they should have disclosed early. That means every case can get through the courthouse door. There's no limit on these lawsuits, and Dudenhofer took away that presumption that continuing to invest in employer stock was generally deemed to be prudent unless there were special circumstances that you should get rid of it. So then the fiduciaries are left with no protection. But anyway, it's a super interesting argument. IBM argues that when you're talking about disclosure to the market, you should be looking to the securities laws, because those are the laws that regulate disclosures to the market as a whole. You shouldn't add an ERISA overlay to these lawsuits. And that case was argued last week. We'll see what the Supreme Court does. The Thole versus U.S. Bank case, that is the third case on the docket. I will say Dorsey is one of the law firms representing U.S. Bank in that case. I am not personally involved in the case, so anything I say here is not based on any inside baseball information. I'm just telling you what I know because I read about it. Greatly oversimplifying the issue in that case involves whether a participant who's in a overfunded defined benefit plan can sue for investment losses related to that plan. A participant in a defined benefit plan is generally entitled just to this stream of payments that you get out of the plan. And if the plan's overfunded, it's got more than enough money to meet the payments that have been promised under the plan. So the question presented by the case is, has that participant been harmed by the investment loss? It's a very interesting metaphysical issue. And the way it plays out is in the standing requirements for bringing a lawsuit. And in this case, there is, you can read the briefing, there are a whole bunch of super technical arguments about standing, the ability to bring a lawsuit under the ERISA statute, and also under the Article 3 standing requirements that are in the United States Constitution, and the interplay between those. And so it's a very narrow issue from an ERISA standpoint. I mean, there's not that many overfunded defined benefit plans that are being sued for investment losses. There just aren't. But the broader issue that makes the case interesting outside of ERISA is how this statutory standing interrelates to Article 3 standing, and that's what's caused it to get more attention outside of ERISA, and that's probably why the Supreme Court granted cert, because I don't think they really cared that much just about the defined benefit plan issue. Question?
To simplify that issue, isn't the standing issue related to the lack of the participants or the failure of a participant to have been harmed directly? In my reading of the case, it seemed as if no one has actually not been paid. No, there has
Yeah,
not
I mean,
been a loss.
that's really the issue. You have to have some kind of,
Repeat the question.
oh, I'm sorry, the question is, doesn't the standing issue have to do primarily with the fact that the participant hasn't really been harmed? Because nobody hasn't been paid and any prospective harm. If the plan's overfunded, the idea of prospective harm is even extremely remote. So that is in fact the question. You need to have some kind of harm, especially under Article 3. You have to have a live case or controversy, and there's a whole lot of words being devoted to that, not just by the parties, but by the amicus and including the government. And so the Supreme Court's going to have to resolve how all these things work together, and at the end of the day, they'll tell you whether a participant in an overfunded DB plan has a case. So so that's the Supreme Court. I got a few minutes left. Wanted to talk a little bit about the defined contribution plan litigation. Liz and Andy talked about that already some this morning, and that continues to be where most of the action is. There's a huge amount of litigation alleging excessive fees are being paid to service providers. You probably saw a couple of dozen lawsuits got filed against big educational institutions that have 403B plans, your MITs, your Columbias, your Dukes, Browns, WashU, a lot of the leading colleges and universities got sued. And there have been some wins for the defendants, but the plaintiffs' lawyers are making decent money on these cases as a whole. So you can expect that these excessive fee cases are going to continue. And at least at the beginning, the target were big plans, because there's lots of money in big plans and bigger damages to be recovered. But as they kind of refine their craft, it will make more sense for them to start sliding down the ladder and targeting mid-sized plans and targeting smaller plans. The issues are pretty much the same. It's just that the dollars are a little different. You might as well pick the riper fruit, and then once that's all exhausted, go after the other stuff. Just a handful of plaintiffs' law firms are behind most of that litigation, including the Nichols Castor firm here in town. Schlichter Bogart's the big one out of St. Louis. They started this craze back in 2006, and they've been doing very, very well. Key takeaways. First, the target of these cases is you. They're suing the plan fiduciaries, the people at the plan sponsor who are responsible for picking service providers and who are responsible for monitoring the service providers. Those are the people who are allegedly asleep at the switch. So you need to be on your game. They're getting quite good at this. And so if you haven't thought about it yet, you should start thinking about it now. The second thing is, if the record keeper and other service providers are being out of plan assets, you need to pay really close attention to the fees and make sure they're consistent with the going market rate for comparable services. You need to understand how revenue sharing works, and whether that revenue sharing is something that you can get back for the benefit of the plan, whether you should be, how much is the record keeper really getting when you add the revenue sharing to whatever you might be paying them in addition to that. You need to do regular RFPs and benchmarking. Liz and Andy talked about that. It all boils down to, there's no single right answer, but you do need to demonstrate that you are aware of the issues and you followed a prudent process in reaching whatever decision you reached. Surprisingly, some big institutions with, billions of dollars in their plan did seem to be asleep at the switch and not paying very close attention to that. I have some information on plan service providers' asset-based fees rather than per participant fees. That as just a baseline allegation, that doesn't hold up. But you do need to be able to demonstrate that the amount you're paying as an asset-based fee is equivalent to what you would have been able to get on a per participant basis. And the Schlichter-Bogart, their recent settlements, they require you to use a per participant fee, but then how you decide to allocate that amongst the plan participants is up to you. The cheaper share class, Liz and Andy talked about that. You need to, if you can, there's no rule that says you can't pick a more expensive share class of the exact same fund. But if you do, you better have a good reason for it. And you better have some documents that explain why it was in the participant's best interest for you to do that. There's all these other things are issues that come up in the litigation. All I would do is say it all boils down to prudent process and the idea that you need to be able to show you that you thought about it and you had a good reason for going the way you went.
Paul, I think we may just want to skip forward just to, given we're basically out of time here, maybe you just want to briefly touch on the DB litigation and the arbitration, maybe a few words on each of the slides.
Okay, yeah, the DB litigation involves challenges to mortality tables. There's a number of cases that have been filed. They're in various stages of resolution. I think 2 of them, the motion to dismiss were denied, 1 they were granted, but the basic issue is the plans are using these fairly old mortality tables to calculate benefits under the plan, or the payments that are made other than as a single life annuity at normal retirement, like early retirement benefits, joint survivor annuity, pre-retirement survivor annuity, years certain on life annuities. These optional forms, they often use a different mortality table, I guess, to calculate those. And some of these mortality tables from the 70s or 80s, or one plan had one from the 50s, the plaintiffs are just saying that's not reasonable. That doesn't make any sense. Those mortality tables don't bear any relation to current mortality. And that's the basic claim. I think, there's plenty of defenses that can be raised, but that's all getting sorted out right now. If you're concerned about your mortality table, you should talk to any of these other people who can tell you a lot more about what your options are. The final one, the arbitration. This is super interesting, and there's a case out of the Ninth Circuit that suggests that arbitration requiring, if you put a provision in your plan document that requires the arbitration of fiduciary breach claims, that can be very, very beneficial. It's this Dorman versus Schwab case, but just to cut to the chase, what Schwab seems to have been able to do was say, if you've got a participant who's suing, like say the plan lost or entered into this relationship where they overpaid their record keeper by $1 million. And then the participant sues trying to recover that $1 million on behalf of the plan. And when you sue under the provision of ERISA that you sue under, you're bringing that case on behalf of the entire plan. And what Schwab said was, well, no, you got to take that to arbitration. And also, when you go to arbitration, you can only arbitrate your individual share of that recovery. You don't get to arbitrate everybody else's recovery. So each participant, theoretically, would have to arbitrate, and they would have to arbitrate separately because they can't arbitrate collectively under the way they wrote the arbitration provision. And it seems crazy, I mean, honestly, but the Ninth Circuit said, yeah, that works. So if that holds up, and I'm not entirely confident that other courts are going to rule the same way, because you do seem to be altering a right that's given to them by ERISA itself, as opposed to some procedural type thing. So I'm not sure it will hold up, but if it holds up, you know, nobody can afford to bring those lawsuits. You have to get expert actuaries, you got to line up all these people, you got to have lawyers who charge a lot of money to recover, you know, what, a couple $100 or $1,000? I mean, it just doesn't make any sense. The effect would be to insulate the employer from a considerable amount of liability for screwing up the running of the plan, but I don't know that it's ultimately going to play out that way. Question?
Employee arbitration clauses. Now, in a benefit plan, is this an agreement? Does the employee sign an agreement that it will arbitrate and waive class action?
Well, no, there's no, the question is, this goes contrary to the Ninth Circuit's case law on employee arbitration waivers and whether the employee has to agree, whether the employee signs anything when they agree to participate in the plan that waives their right to class actions. And the answer is, I think typically they don't sign anything. It's just when you're deemed when you participate in the plan, you're deemed to be operating under whatever rules are set out in the plan document. If the plan document says that you have to arbitrate any disputes related to the plan, and if when you bring these actions, you're bringing these actions on behalf of the plan, you know, it's not a stretch to say that arbitration provision directly controls the case you're trying to bring. So I think, I mean, it's a hugely interesting idea. I will say that Schwab wasn't totally confident this was going to work. They built a fail-safe into their arbitration provision that said, hey, if it doesn't work, if it turns out that we can't force him to arbitrate just his individual interest, then he doesn't have to arbitrate at all. He gets to go to federal court, because as the employer, if you're talking about a big fiduciary breach claim, you'd almost always want to be in federal court. You got procedural protections, you got motions to dismiss, you got the right to do more extensive discovery, and especially you've got the right to appeal a decision that is just incorrect. If you're in arbitration, your ability to deal with an adverse arbitration award is extremely limited. Arbitrators don't have to follow the law. If they don't, you can't do anything about it. I mean, many of them do. They're good, solid people, but there's no guarantee and nothing that you can do if they don't. But anyway, I went over time.
No, that's perfect, Paul. Thank you. I know we're actually a few minutes over, and we appreciate your patience with us here. We're all going to stay up here, so if you have additional questions, we'd be happy to take them. But we should probably just say thank you very much for coming to today's seminar. Thank you.